everybody, and welcome back to the show. Well, when you think of expunging a criminal record, you might think that it's simply a matter of erasing an arrest from your record and having it disappear forever. Well, not so. And Judge Paul Bonin is here to help us better understand what the law allows.
Judge Bonin sits on the Louisiana 4th Circuit Court of Appeals, and he is formerly of the New Orleans Traffic Court. So he knows a lot about expunging items from a person's record. Judge Bonin, by the way, congratulations. You got a new term, just starting a 10-year term on the 4th Circuit Court of Appeals. Why don't you tell us what are expungements and how do they affect people's past arrest and conviction records?
I think the most important thing, first off, thank you, John, for the congratulations. But the most important thing for a person to understand about expungements is that what it is doing, it's sort of covering up an arrest record or a conviction record from public view. The arrest stays on the police record. It's still accessible, and the police and prosecutors can get to that information. It doesn't disappear, Shauna was saying in the opening. It doesn't disappear. It's there, but it's concealed from public view. So for someone who's going to get a job, who's gotten that arrest record expunged, it's concealed from a prospective employer.
But so if the employer asks me, have you ever been arrested? Can I legally say no, or I have to say yes? What do I say?
You can, under our law in Louisiana, if your arrest was expunged and you're requested, have you ever been arrested? You can say, no, I have not been. You can answer that truthfully in that way. There are exceptions which are very important. For example, if you're applying to nursing school, or you're applying to social work school, or law school, medical school, there's certain exceptions that take you out of that. So if you're going to work in a daycare center, the fact that your arrest was expunged, you still have to disclose that.
Okay.
And usually the applications will tell you that.
Okay.
You know, now would be a good time to mention that in connection with today's topic, we did our homework. We did some extra research, and we invited 2 local attorneys, Gene Redmann, who, full disclosure, he's my brother, but a criminal defense attorney who also does personal injury, but for 20 years does a lot of this stuff, including expungements, and Matt MacLaren, also a former district attorney in the Orleans Parish office, and now doing a lot of criminal defense work, including expungements. And we talked about that topic specifically. I would worry that the way these applications are, sometimes they'll ask, do you have any convictions? Some will say, have you ever been arrested or convicted? Besides my concern that it's simply unfair to say, have you been arrested? You may have been wrongfully arrested. You were in the wrong place at the wrong time. But if the expungement comes from setting aside a conviction and then expunging the record from public view, like you clarified, I worry about an employer who says, well, wait a minute, you were convicted, you were arrested, but then you got it expunged. But you lied to me. You were arrested. So just tread carefully on that. And like you said, law school, nursing school, some job applications, you might need to find out for sure exactly what you have to disclose and how to disclose. But look carefully at the questions. Look, how is the question worded? Do you have any convictions? Today I don't. It got all expunged. You can honestly say, no, I have no convictions. And so just be careful.
Yes, and you know, and of course the other thing that you need to be aware of is that on those exceptions I was talking about, typically what they're going to do is they're going to ask you, have you had any expungements? But if you have, you don't, if it's not an exception, you do not have to disclose that under our law in Louisiana.
So I could say no. If I have had an expungement, I can say no, I haven't had any expungements.
Yes, truthfully.
Wow. What can be expunged?
Well, what can be expunged is any arrest which did not result in a conviction. That's number one.
Or a plea to pleading to a conviction.
Right. In other words, if you plead guilty or you're found guilty, some of those can be expunged. So the conviction that results from your admitting to a crime or a misdemeanor, those can be expunged under certain conditions. Typically, you have to make that arrangement ahead of time. So when you're making your plea to a felony particularly, you have to say, look, I'm doing this under that provision of the law that lets this get taken off my record later. In misdemeanors, it's a little easier because misdemeanors really are not as serious. And so it's a broader way to do it. but you don't have to always do it ahead of time. You can come back even after you've pled guilty to a misdemeanor and ask for it to be expunged.
Let me add to that, and this is very important. If you got arrested for DWI, if you got arrested for a minor offense, maybe it's a felony, number one, you ought to have legal counsel. Number two, whether you have counsel, a public defender, or you're doing it on your own and you're given the opportunity to enter a guilty verdict or plead to some lesser offense, okay? What the judge is referring to here is you plea under something called Article 894 or 893 under our Code of Criminal Procedure. That's critically important. When you plead under one of those two articles, one's for felonies and one's for misdemeanors, that is what allows you later on to come back and get an expungement. And if you don't specifically plead under one of those two articles, then later on you may not be able to get it expunged, the conviction by judge or jury, or the plea of guilty. Is that an accurate statement, Judge?
It's pretty close. With the felonies under 893, that's completely accurate. With the misdemeanors under 894, you can, on some circumstances, come back later, even if you did not set it out ahead of time.
Good. Well, good. Then you even have a little bit of the door's cracked open a little bit for you.
It
That's
is.
good.
It is. But the important thing to remember, especially about DWIs, because that's one of the most typical places where people are looking for it. And this goes back to what I was telling you before, Sean, about the difference between that it's concealed and not erased or disappeared. If you get arrested for DWI and convicted, and you get it expunged, you get that conviction expunged, but you get arrested, let's say 3 years later, and you prosecuted for that second DWI, they can go back and say, well, this is your second. The expungement doesn't protect you from that. You see, it still stays on your record.
There.
So then it becomes public once again if you reoffend or if you're charged with reoffending.
Well, so then does that influence the punishment?
Oh, absolutely. Absolutely. So it's not a deal of where you don't have to worry about it and it's gone away forever. It's there. If you don't reoffend, well, nobody ever finds out about it.
Nobody finds out. You're okay.
Right.
Yes, but if you reoffend, it's going to come back.
It comes back.
It does come back.
I don't want to I want to stay on this topic, but related to traffic offenses, you heard as you were getting ready to come on the set, us talking about this terrible situation, the distracted driver who killed a child. As a traffic judge, you spent years on the traffic court bench. Do you have a comment? Just maybe, we're running short on time, but just a little comment on distracted driving, and what did you see as a judge presiding over cases?
Well, really a lot of what y'all were talking about, I've been in the Court of Appeal for the last 4 years, and I've seen a lot more distracted driving on the streets than I did in traffic court. Except I will say this, I think it is an even greater threat than DWIs, people driving while intoxicated, because even DWIs were almost always contained after 6 o'clock, 9 o'clock in the nighttime when the roads weren't that crowded. Now people are distracted driving at all times, day and night.
Everybody's got smartphones. Everybody's got cell phones now.
Yeah.
And there's just more cars on the road, at that time of night. If people were driving drunk during the daytime, we would have a much higher incidence of tragedies. And so I think it's the single critical traffic safety issue of our time.
Very curious to know, when you're talking about expungements, adults versus juvenile, are there a lot of differences there? Or is an expungement an expungement?
You really don't need an expungement in juvenile cases, because if the case was handled in juvenile court, which is typically where it would be handled if it was, that stays private or stays concealed from the public in most cases. So there's no process for actually expunging it because it wouldn't be known publicly regardless.
Publicly anyway.
Right.
Okay. Unless this juvenile offends as an adult.
Well, right. There can be some instances where what took place with the offense in juvenile court that was handled can be made public. And of course, in a lot of cases too now we see cases that start out in juvenile court can be transferred to adult court.
Okay, all right. That's very, very interesting. We have some viewer questions. Will you stick around to take those questions?
Absolutely.
All right, well, that's all the time we have for this segment. But coming up next, we'll be taking your questions for John and Judge Bonin, so stay right there. We'll be right back. Welcome back, everyone. It is time to answer our viewer questions, and we've been getting some great ones all week long from Twitter, from Facebook, and email. So let's get to those right away. Our first one comes from Amir, who writes in and says, if I'm applying for a green card, do I have to disclose that I've had a conviction expunged?
Yes. The easy answer is yes. And of course, you want to do it because you are applying to the federal government besides, and they are one of the exceptions, but they already have the answer. So it doesn't hurt you to be forthright on that.
Okay, all right.
And I would just add to that we talked about certain employers that you have to reveal certain things to. The last thing you want to be doing is when you're speaking to the federal government is have them think that you are not being forthcoming with the facts. I would say I had a conviction for whatever it is. I was eligible to have it expunged. I have had it expunged. Provide the documentation. Talk to an immigration attorney about how best to navigate those waters. That's not my area of specialty, but talk to an immigration attorney about how best to proceed.
Right.
Because we know that after you get your immigration status, if you get a conviction, certain convictions, that can jeopardize your citizenship.
Wow.
So please talk to an immigration attorney if you have a shot at getting a green card, citizenship, residency. It's certainly money well spent.
I think it's very important because some people might automatically think, well, if I disclose that information, it's really going to hurt me. But it sounds like what you're both saying is that by not disclosing it, it could hurt you perhaps even more.
Right, exactly. Let me emphasize something that John said too. For a person who has not yet received their citizenship, they should always make their lawyer aware and the judge aware of their status, because it could have consequences, as John was saying. And so they want to be much more careful about voluntarily entering a plea to certain offenses because of consequences with immigration status.
Okay.
So I think that was
Yeah.
excellent that you pointed that out.
Yeah, and let me that's worth taking 30 more seconds. In other words, if you are in the country, in the United States, and you're pleading guilty to a crime, well, suppose you have a green card and you're pleading guilty to a crime. That can affect your citizenship. So extremely important, and I'm glad that Judge Bonin highlighted that. If you're pleading guilty to a crime and you're legally in this country and you got citizenship after coming here, or you came here with permission and got residency, and you're pleading guilty to a crime, you better do that with the advice and consent of an immigration attorney, not just your criminal court attorney who may know nothing about immigration law. That's a really good point.
Well, you know, while we're talking about using an attorney, not using an attorney, I actually came across something on the internet, which was an expungement kit, self-expungement kit. Can people do this on their own, or should they have an attorney? How difficult is this?
I mean, I wouldn't do it on my own off of the internet.
Yeah.
I'd go down to the courthouse and ask someone at the court, if you were, or let's say you were just arrested and nothing ever came of it, you ought to get that off your record. You really should. You should get that expunged from your public record. But go to the courthouse, and they have the forms there, and they can assist you, and it shouldn't even cost you anything.
Okay.
But over the internet, I would be very leery. And don't you agree, John? Like when they do these deals about you can just
Anything
write
you
your
do
own
over the
will.
internet,
Right,
I would be
right.
very wary. And but let me add this: we're going to put on the John Redmann Power of Attorney or John Redmann POA website some forms that are offered at the various courthouses, St. Tammany, Jefferson Parish, and Orleans Parish. Some forms that are available, and they're going to look like this. You'll be able to download the PDFs. However, also on my website, we have an extended interview. It lasts about 10 minutes with these two attorneys we talked about before, who talk about the pros and cons of trying to do it on your own. Certainly, you can try it. You may have success. They indicated that there are some fees that some courthouses charge for just doing it all on your own. But you also need to do a motion to set aside conviction. Do you know how to do that? You need to be careful about it. And so watch the segment on there. You'll get some insights. Try and do it yourself. Maybe you'll be successful, and it's all good.
Okay.
But if not, you may need to follow up with an attorney.
Okay, all right, let's go to Lynn. She posted a question on our Facebook wall. She says, do you have to wait before getting an expungement, and is there a time limit for a criminal record to be automatically expunged?
Well, first off, there's no such thing as an automatic expungement.
Okay.
So anybody who thinks that, you know, and there's no such thing that just because your lawyer told you it was expunged, that it's expunged.
That it's actually expunged? Okay.
Yes.
That's important to know.
A lot of times
That's
lawyers
very
say that
important
and
to
they
know.
don't do the paperwork.
You mean they
Wow.
can't trust all lawyers?
They really can't. A person should ask for the proof, certified copies of their expungement records,
Okay.
you know, of the
And they can go to the
expungement.
courthouse and request copies of their own records themselves.
Yes.
They
But-
might charge a few bucks for a certified copy, but
Okay.
but
So let's get that language out. No automatic expungement.
No automatic expungement. Secondly, if you are trying to get an arrest expunged, you typically have to wait unless the DA is willing to sign a paper saying, I will not prosecute you ever for this offense. You have to wait until all the years are over with from the time that you could be prosecuted. There's certain statutes of limitation depending on whether it's a misdemeanor or a felony or what kind of a felony. So, but the DA can short circuit that if the district attorney
usually
wants
it's a
to.
couple of years for most crimes unless it's murder, in which
Yeah.
case it's pretty much forever.
If you have pled guilty, but then you did it under this procedure, as John was saying, where the plea of guilty is going to be set aside, the judge is going to. There's two procedures. Sometimes you plead guilty, but the judge doesn't accept the guilty plea, puts you on probation. When that period of time is finished, then you come back in and you get it expunged. The other procedure is you plead guilty, the judge accepts your guilty plea, you put on probation, and then at the end of that period, you come back in and ask and go. So it's usually, you have to finish the probationary period.
You have to before you can actually, okay.
Get the expungement.
Get the
right.
expungement. Okay. Marcella has a question. She says, how can one get drug charges expunged? Very old drug charges for a man who has changed his life and wants to be able to work and support his family and get a good paying job. That apparently is the example that she's giving. And I would imagine that there are lots of cases like that.
Yeah, there really is. What the person should do, it depends on what kind of a charge it was, because if it was a distribution charge, it's not going to be expunged. But if it was a possession charge, they might be able to go in and file some sort of a motion with the judge, even many years later, saying, would you consider changing the arrangement? In other words, going back and asking, let me act as if I had done it the correct way to get this benefit. And depending on the person's situation. But a lot of times, too, yeah, it depends on how old it is, too.
Okay, all right. We're going to go to Mike from New Orleans. He writes into us. He says, why do you have to file for an expungement if you are acquitted? Shouldn't the judge be able to automatically, there's that word again, strike your record?
It's a good question.
It's a great question, and that's not to be addressed to the judge, but to the legislator, you know, the person who writes the laws.
Right.
And that probably ought to be what happens, you know, but it's not the law currently.
Currently, yeah.
And but I would suggest to Mike that he find out who his legislator is, point out that problem to him, and see if maybe they could get it changed.
Okay.
And I would suggest to Mike, too, that while he's at it, if you're arrested and no charges are brought, your arrest should automatically be expunged, too.
Okay, all right then. And our last question, can an employer in Louisiana find out about my arrest in Florida should I try to get it expunged?
The answer, can he find out about it in Florida? Yes. Should I try to get it expunged? In other words,
Go to Florida.
Yes.
Yes.
Go to Florida and try to get it. Yes.
Yes,
The
yes.
two answers, simple answers. Then yes,
Yes
you can,
and yes.
and yes. And that's really the answer to any viewer. If you can get your record expunged, publicly concealed, do that, because there are a lot of people cannot get jobs because of their records.
Okay, all right. Judge Bonin, thank you so very much.
Thank
We've
y'all
learned
very
a
much.
lot today. Thank you for coming in.
Thank you.
Judge Bonin, it's been a pleasure having you on the show. A lot of useful information. We look forward to having you back another
Thank
time.
you.
Thank you again. God bless.
Thank you, Shona.
That's all the time we have, folks. Shona, thank you again for being with us. ladies and gentlemen, but join us next week for another episode of John Redmann, Power of Attorney. Hi, welcome to John Redmann, Power of Attorney. I'm John Redmann, and with us for this special segment of the show is two attorneys who practice in the area of criminal law and who do expungements. We're going to go right into the topic. I have with us today attorney Gene Redmann, my brother, full disclosure, and attorney Matt MacLaren, also a former prosecutor in the Orleans Parish District Attorney's Office. Gentlemen, thank you very much for being with us here today.
Thanks for having us.
Let's get right into it. Gene, let me start with you. Why don't you define what expungements are and how do they relate to arrests and convictions?
Expungements technically mean that you have your conviction expunged or erased from your record, or in cases of acquittal, or if the DA decides to drop your charges, you have your arrest expunged or erased from your public record.
Okay. So for instance, I think many viewers out there watching the show, watching the segment, they may have in the past gotten in trouble. Could have been something minor, could have been something more major. In some instances, they may qualify to have old arrests, old convictions, wiped clean from the slate effectively. Matt, why don't you tell us, you used to prosecute people in the DA's office in Orleans Parish. Some people they would plead guilty, or they would plead guilty to a lesser offense. Tell us, what are options? Why don't you answer the next question? What are the options for people who get these convictions, or maybe it's an arrest that never got a conviction? What can people do to clean that up?
Well, I mean, obviously it's a major tool of prosecutors. It's a negotiation tactic, if you will. We offer, or when I was a prosecutor, we would offer the option of an expungable offense, so to say. And basically what it was your ability to, take responsibility for something that may have happened and have the option of taking it off. So the option really comes down to, once you plead pursuant to the Code of Criminal Procedure Article either 894 for misdemeanors or 893 for felonies, to be able to come back later after you completed everything and effectively have it taken off of your record.
Well, let me stop you right there. When you plead guilty to an offense,
right,
maybe the offense that's on the table, or a lesser offense because of a plea arrangement.
Right.
Maybe the DA is not certain to get a conviction, but he's willing to go to a lesser offense under 893 for felonies and 894 for misdemeanors. You're telling them that after a certain amount of time has passed, if they behave, if they do all the terms of the what do you call it? Probation and whatnot, they could come back to the court later on and say, look, I've done everything as I was requested. Now I want you to expunge or take it off of my record. Did I get you right on that?
Yeah, that's exactly how it kind of goes down. You come back to the court with your motion and your order done, and the judge reviews it. The district attorney has an opportunity to be heard about whether they want to agree to it or not. And then if everyone's in agreement that it should be expunged, the judge signs it, you pay the fees, and it's effectively taken off your record.
Gene, you've been practicing over 20 years, a lot of criminal defense. What happens if somebody is convicted, but there's not that 894 or 893 condition, that article of the Code of Criminal Procedure condition 893, 894?
Well, unfortunately, if you don't work out a plea agreement where you plea under the correct article, 893 for felonies, 894 for misdemeanors, you don't have the expungement available to you. So that's why it's important to talk to a knowledgeable attorney before you get to that stage, and make sure if why a plea may be favorable to you, rather than rolling the dice with a trial. And for most non-violent crimes, that expungement is available to you.
Okay. And I don't want to forget to say, if you are arrested and it leads to no conviction or no plea deal at all, maybe they decide they're not going to prosecute you, or you go to trial and you win, and faith smiles on you and your innocence is revealed at trial, no conviction whatsoever, no plea deal, there's an arrest record out there, you can get that expunged too, right?
That's correct. And
right.
as a matter of right, the state has to take that off your record because you are an innocent man. So
You still got to jump through the hoops. You still got to do
go
the
through
paperwork.
hoops, but no fees. You won't have to pay the fee. The fee gets waived as a matter of right because you've either been acquitted or the district attorney has decided that your arrest, let's say, was not
And let's
correct.
be clear about fees. The state charges fees every time you go in, request an expungement. The fees to the state in an arrest where there was no conviction or plea, those fees are waived. But if you have an expungement, you may be paying fees to an attorney who's got to go through a lot of hoops to get that
Right.
expungement done, right?
You may contact an attorney and say, I've been acquitted, and that attorney may charge you a fee for him to go through the hoops while your state fees may still be waived.
Okay.
Or you may hire an attorney and say, I pled guilty pursuant to either 894 or 893, and I want this expunged, but those are state fees that are mandatory that cannot be waived.
Okay. Can people do this expungement steps, the expungement steps on their own? Can they go to the courthouse and say, I had a 893 expungement a while back, I did everything that I was supposed to do, I'm pretty sure I'm eligible for expungement now. Can people just try and fill out forms themselves and not hire a lawyer and not incur that
Anybody
expense?
can represent themselves, but you know the old saying is a lawyer who represents himself has a fool for a client.
Right. It's very risky.
Right.
And just from your experience, when you, Gene, why don't you answer this? When you're trying to do an expungement, is it just fill in the blanks, check off the checks, give them pay the fees, and turn it in, and you're done?
Mostly no. Certain courts, for example, New Orleans Traffic Court has a fairly simple expungement process that a lot of people could probably do. But most courts require that you set aside your conviction first, in the case of a conviction, for example. And they don't have forms for that. So
Preconditions, things you got to get done in association with requesting an expungement.
prior to the expungement, you have to have your conviction in cases of where you've pled or been where you've pled to have your conviction set aside. And my experience is that most people can't do it.
So you've probably had people come back to you and say, I tried to do it, but I hit a brick wall. It turns out I did it all wrong, and they got to do it all over again. And then they pulled out a lot of their hair, and now they're coming to see you to get it right.
Many people do that. They try, and not to say no one can accomplish it. Plenty of civilians can do it, but it's relatively affordable. Most attorneys charge affordable fees, and it's a smoother process, and you're much more likely to get it accomplished.
All right, and we're starting to run short on time here. I'm sure people want to know, gee, if I got drunk in Bourbon Street one time when I was younger. And by the way, if you had a crime when you were a juvenile, not in adult court, but juvenile court, people don't have to worry about that, right?
I would say, yeah, you wouldn't. No one's really going to find out about that because your juvenile records are sealed.
They're sealed automatically.
Per the state.
Okay. But what does it cost to get, just in the greater New Orleans area, Metairie, Jefferson, Orleans, St. Tammany, approximate cost to get an old conviction for a misdemeanor or a felony expunged? Just give a rough idea, because we're short on time. I want to get to the last question or two.
A regular misdemeanor will usually cost you, if you include the court fees, which run anywhere from $300 to $400, will cost you roughly between $1,000 and $1,200.
Okay. If it's more complicated, if it's a couple of convictions, if there's some red tape, the cost can go up, but you'll know that going in, and you get a free consultation with pretty much any lawyer if they just look in the yellow pages or go online and find a reputable lawyer.
I would say that, yeah, most lawyers that you contact will do a consultation, and most lawyers aren't even going to really make you probably come down to their office and sit down and go through this whole thing. They can probably do it over the phone with you.
Well, we're just really short on time, so let me just get to another question, and this was one of the questions that people wrote in and asked: what is a person's responsibility to disclose a conviction on, say, a job application or maybe a school application for college or graduate school?
Well, clearly you want to tell the truth on the application, so it really depends on the wording of the question. For example, if the application says, have you ever been convicted of a crime? And in fact, you have been convicted of a crime, even though you've had it expunged, you were still convicted and you had the conviction set aside. And now,
The truthful answer is
truth answer, yes.
Yes,
However,
but
expunged.
I've had
my,
it expunged.
my conviction has been set aside by the law, and it has the same effect as an acquittal now under the law, versus if the application says, do you have any convictions on your record? And if you've had a conviction set aside, you don't. So you can
no
truthfully
longer
say,
have
I
a conviction
don't.
on your record set aside. All right, well, gentlemen, we're very grateful to you both for joining us on John Redmann, Power of Attorney. We hope that everyone who sees this segment, if you're interested in more on the topic, we have Court of Appeal Judge Paul Bonin, formerly of the Traffic Court, on the segment this Tuesday. That's October 16th. You can watch that segment also on this website. Thank you very much for being here today, and we look forward to seeing you another time for more criminal defense attorney perspective. Thank you very much.
Thank you, John.